So, a very good morning to you all. I am John Miller, founding attorney of Rock Solid Law. Started my own firm in 1991 here in the Jacksonville Beaches area. And we practice in three areas. That is estate planning, which of course includes today's subject, probate, real estate, and then I represent entrepreneurial small business owners. Small business is the heartbeat of American economy, just as I believe that an estate plan is an essential foundation of your family tree. And one of the things that you really need to take into consideration with respect to planning your estate is the probate process. If you're a Floridian, going through that process and what that means to those you left behind and your legacy. I forgot to turn the fabulous Commodores and Lionel Richie off this morning. You know, that song is from 1977 and was entitled Zoom, which I think is kind of hilarious in 2020 when we're zooming all the time. So welcome, congrats. We try to keep these between 20 and 40 minutes, packed full of information. I will always take questions during the session, and I will leave time at the end to pick up any that come through as well. Welcome. We're busy right now. We're doing a lot of work during this period of time, helping families plan their estates. And one of the things we always like to talk about is the probate process. One of the things probate can interfere with, honestly, is celebrating your legacy. And our focus in our estate planning is all about your legacy and taking care of your family tree as it goes forward. We focus a little differently than some others. Of course, we focus on tax considerations, and of course, we focus on the future of your family, but we focus on your values. And we really like to get to know you as a person and know what it is you care about so that we can write your life story into your estate planning documents based on what you really care. And so that after you've used your stuff, you show your love to those you treasure after you've passed on for their lives. So, what does it mean to have a will? A last will and testament. It means, congratulations, you're in the top 20%, because 80% of Americans don't even bother to have a will, which means they die intestate, which means the laws of the state they last lived in and probably died in determine what happens to everything they spent their life working for. Additionally, they will go through the probate process necessarily because a judge has to apply that law. So if you are to create an estate planning package based on a last will and testament, you will also go through the probate process. So I want to tell you what that process is like in a short version this morning. What it means is that you've decided, you have made the decision, not left it to some judge that you don't know, who's going to take care of your affairs, who is going to take care of your children, particularly if you have minor children, who is going to be the ones to raise them and manage what you've left behind for them, and who you want to receive gifts from you after you've gone. Now, that can be money, that could be real property, that could be personal property, that could be anything that you have control over. With the will, those you love will be involved in a lawsuit, and that's what probate is. So when you hear probate, you need to think court of law, a judge presiding. You're not going to court, your estate is going to court. Those that you have left behind are going to spend time with a lawyer going to court. So a little bit about that. But first, we're going to take a quick quiz. Ready? Have a pen and paper, or just do it mentally. After you die, or the second of a married couple dies, do you want your closest family secrets to be private or public for anybody to see? 2 of 3 is a short quiz. Do you want your estate to be distributed quickly or in a long, drawn-out court process? I think you see where I'm going, right? Third and final question for Double Jeopardy. Who do you want to receive what you worked for during your life? and you can check all that apply. A, people you love and or care about. B, charities or others that affect your legacy and about which you care. C, people you dislike immensely, like lawyers you don't even know, accountants, appraisers, phony creditors, etc. Guess what? 80% of our fellow American citizens include C in the choice they've made by not making a choice at all. Let that sink in. Really? Do you think that's what people want? I'm going to tell you during this call, probate is the right process for some people. And I'll tell you who those folks are. And if it is the right call, we are happy to provide that service for you. All right? Here's what 8 out of 10 people, that's the 80%, right? It's 8 out of 10 go through with the probate. It gives you unwanted publicity. Bottom line, your dirty laundry is aired for anybody who knows how to do it to go find it and read about it. It is very rare that there are probate proceedings, which are official court documents, which are kept completely secret. And there are people that go snoop around. They might be your neighbors. They might be these fake creditors I'm going to talk a little more about that go and look. Probate also means there's going to be a long time before your heirs receive the gifts you have left for them. Because any assets going through your probate estate will be subject to court order, and your personal representative, for those of you that have moved here from other places, that's the same thing as an executor or an executrix. Personal representative is the person that you've designated, a friend, a family member, you can hire a professional, who will take care of shepherding your estate through the probate court. Are going to work for no less than 3 in the case of a very small summary estate, likely no less than 6 in the case of a formal probate where, and I'm going to talk a little more about that in a minute, where we have to actually have a filing and get letters issued and all those sorts of things and give notice to creditors, which will last for 3 months. So no less than 6 months, but more likely a year. It's not uncommon to see it last 2 years or 3 years. And let me tell you about that. So your heir likes to play tennis, likes to go surfing, since we're beach people, likes to do anything in the world other than what they're going to have to do, which is instead of going on with their lives, go down to the courthouse and wait until the judge gets ready to call their case and spend a few hours with the lawyer who's trying to figure out how to get that case through the court and take care of what you've designated. And finally, the truth is, people you don't even know are going to benefit from what you have worked a lifetime to earn, right? And some of those people are lawyers. And I will tell you absolutely that there are law firms who, as a long-term business plan, put their clients through probate because they can make a lot of money about it, out of them. Why do they care? Those lawyers are going to be retired probably, right? Guess what they do before they retire? They sell their interest in their firm, or they sell their firm. And your estate becomes an asset of that, because someday, somebody who may not even be in law school yet is going to take that case through probate. Why? Who do you think your heirs are going to go back to? The firm you started with, okay? So, this is the biggest point for me, because I practice a little differently. When you pass, we want you to be celebrated. We want your legacy to be adored by those that loved you the most, right? This goes for everybody. This goes for everybody. But instead of getting to have fond memories of you for the period of time that this probate lasts, those folks have got to be involved in a lawsuit, a court suit. Don't you think that's going to be kind of like reliving your death every time they have to deal with it? And guess what? Here's the sad truth. I've practiced since 1984, right? You do the math. I have seen it. Probate is where the fangs and the claws come out. Probate is where family fights go to happen. Probate's where fights that maybe were going to get swept under the rug come out of the woodwork. I have seen, for very small amounts of money, siblings, sisters, brothers that are never going to talk again. And it's because they went through this probate process and they fought. You know, a lawsuit is a legal battle. You see the signboards just like I do. We fight for you, right? Hire us. We're the toughest. We're the meanest. Guys, I litigated for over 15 years at the start of my practice. I got out of it because I don't like the fighting. I'd rather help families take care of their heirs for generations to come. When you go to a lawsuit, it is a pitched battle. And the people that do that for a living, they love it just like athletes love to compete. It's just using their minds and their, I'll call it acting skills, to get the best result for their client. So if one of those heirs hires a lawyer and goes through that process, the other ones have to live through it too. Now, the real thing to consider when you have only a will is your first problem is that you've done nothing to alleviate, I've been over it, the excessive cost. 3, 6, 10% shrinkage is normal. Excessive cost, delay, and publicity of probate. I call probate a voluntary tax you impose on yourself and your heirs. You don't have to pay it. You can plan around it. So there are estate taxes, capital gains taxes, and probate that are all voluntary. You know, some studies have been done that show that the shrinkage in an estate is typically 30 to 60%. This is the second death of a couple, 30 to 60%, and it happens 80% of the time. So you have a will. Did your lawyer not advise you about all this? Are they incompetent, or did they do it on purpose? Because it has to be one of the two. Now, I wanted to just take a moment and go over a probate matter. I'm covering up all the important data. This is a litigation index of an average formal probate. You will see that there are 18 things involved, and this one did not involve real property. So I'll make myself a note to make sure I go over the homestead when we finish. So we have to record with the court a certified copy of the original death certificate not indicating the cause of death. Okay, that doesn't sound like much to any of you, but even this week I've had the one that comes with the cause of death and had to send somebody back to the funeral home to get the other one. It's a hassle. Shouldn't have to be done. We petition for administration. That's basically the complaint. That's how you open the lawsuit. The person who is being chosen or will be appointed as the personal representative has to take an oath that they will carry out that capacity as a fiduciary. Then in most instances, there is no Florida estate tax due, so we have to have that person file an affidavit regarding that. In some cases, they've got to take care of getting the final tax return filed as well. I would advise that that's probably in most cases. There's going to be an order where the judge appoints the personal representative. So the judge has to say, hey, that person you said meets the qualifications and they're okay. It can be contested. I've seen litigation over this. One sibling's mad they got left out and they want to be the one. Or that person did bad things to me, usually having something to do that happened around the age of 12, and they fight it. They fight it. So what happens after that order appointing the personal representative is issued is called letters of administration. You've probably heard of getting your letters regularly. So letters of administration occur regularly. Occur at this point in the litigation. That is the thing that allows the personal representative to start taking over the business of the person who passed away. We'll help you get an employee identification number, an EIN, from the Social Security Administration in the event that one is necessary for the estate. Then we have to give notice to creditors. So we prepare a notice, and all creditors that you're aware of, we have to send it to, right? A lot of times that has to do with the last illness. And those that you aren't aware of get it by a notice of publication, which is published in certain newspapers, usually the business press, that advise the world that the estate is being administered in a probate, and that gives them the opportunity to file a claim indicating that the money is owed to the estate. That must run, and then we must serve a proof of service that we had done, that we had served the right people, and we're going to file a proof with the court that it was properly published. Now, I alluded to it earlier. What happens is that hospitals and places like that, healthcare providers and creditors, like your credit cards and stuff, have people that regularly monitor this. So when they see somebody's name come up that they had a business relationship with, they're going to file proof that they are owed money. And then your personal representative is going to have to see what you've got in your estate and how that can be paid out to them accordingly. Now, in this matter, there was another interested party. I don't remember if it was a spouse or another sibling, but they chose to waive their notice. So there's a waiver in here that we created for their signature in order to do that. Now, when these notices of creditors go out, the other thing that happens is there are unscrupulous people out there that watch the probate files, and they will actually file a proof of claim stating that they're owed money, and it's not a very big amount. Might be a few hundred, might be only tens, and they'll do it over and over and over again until they're caught. And because your personal representative is missing you, and because they're stressed out about this thing and not paying the kind of attention they really should, they'll just go ahead and pay those people. So people get paid on false and fraudulent claims that had no business in your business. But they're doing stuff like that these days, and you know it because you've had phishing attempts on your computer, and you've had people call your cell phone or your home phone to try to get money out of you, and you know there's scammers everywhere, and this is just another area of scams that can be avoided. So then you file an inventory. That's a list of all the stuff you have, not like your guitar, but like all your accounts that are going through the probate and all of the assets, including real property that's going through the probate. So there, right there in the public record, all your stuff's listed, and smart people can go find out what that was. Then you have to prove that you served that to the creditors. You get my gist? This doesn't happen in a day. We're about halfway through. And then we file a notice of confidential information in this one, asking the court to seal the inventory information, which we hope they will do, and we hope that it's safe, but it's down in some clerk's office somewhere in the bowels of the courthouse. We're going to file after the notice period runs, which is, as I indicated, a minimum of 3 and usually more months later. We'll file a statement regarding creditors. That's telling the court who filed a notice that they're owed money. In this action, we filed another waiver, and that was so that the personal representative was not required to do a full accounting of the matter, which goes to a whole nother layer of cost, expense, delay, time, etc. when you do. This was a small family, so that wasn't required. So after the claims have been paid, and after everybody has accepted the inventory and the accounting, if there is one, then you petition the court for a discharge. This was a pretty fast one. This was just a little over 6 or 8 months. So we were able to get this family through quickly. It was a single adult child of a married couple, where one of the parents had passed. Lots of cooperation in this family, which is one of the reasons we took it. I don't do any intense litigation anymore, so we would refer that out. Then the clerk of the court has to review it. Takes about a month. Took 6 weeks in this one, and gives a report to the judge, hopefully that everything is in good shape. If there are any errors found, you got to go back and fix them. And then finally, the court will enter what's called an order of discharge, which ends it and allows the personal representative to distribute the assets. So as I said, let's see, this one was a pretty simple one. 9 months went by. So had there been any hiccups in it, it would have definitely hit a year or more. So homestead, this matter didn't involve the home because it was the first to die of a couple. And let's see, I believe she was intestate, so we didn't have to produce the original will, but also there was no homestead property going into it because the husband actually inherited that immediately on the death of his spouse. But if there's a homestead is not part of the probate estate, but you've got to tell the court it exists, prove that it's homestead, and then get an order regarding homestead, which takes it out of the estate. And in that case, in many cases, then it's available for sale. This is one of the things that I think is probably interesting to the realtors that are on the call this morning. That's what we have to do to get a homestead property ready to sell. And I know it's often frustrating because with low inventory at this point, we want to get those homes on the market while the market is so hot, but we have to go through the court process, where if it had been properly left, either through a ladybird deed or maybe through a trust, you could put that thing for sale right away. So you've got to decide, everybody's got to decide whether it's important to preserve what they've earned and pass it on to who they choose. And what I want to encourage you to do by talking about the rigor of the probate process is to encourage you to be engaged to fight for your family. Don't just let this happen because you never thought about it, right? You're educated now. You know what the process is. And you now can choose that you want that for your family or not. So I kind of always enjoy this part, and I hope you've got a little bit of a sense of humor, because I like to say my conclusion is that probate really sucks. It sucks away wealth. It does. There's no doubt about it. It's going to cost your family money and time and give away privacy. So you're going to have lawyers, snoops, fake creditors, things that go bump in the night. It's where families fight. I did litigation. I know what court's like. I got away with it because I don't agree with it. We got the best judicial system in the world here in the States, right? Yet it still is only best on average. So sometimes somebody wins that shouldn't, and somebody loses who should have won, right? Let's keep our families out of that. There's a simple way. Go to our website and watch me talk about trusts. There's a simple living trust that can completely blow away the possibility of this future for those you love. Oh, and once it gets on the public record, it stays there forever, or until the courthouse burns down. But now that we have electronic records living in the cloud, it's not going away. You know, I'm just amazed always by the superstars, the uber rich, who just can't be bothered to take the time to put together a simple estate plan that would take care of all of this and never allow their families to have to go through this. In my opinion, okay, big O, this is my opinion, estate planning should be about keeping all or as much as possible of what you've earned for who or what you want to share it with. All at the least expense possible, short-term and long-term. We want you to avoid probate. And if you want to avoid probate, set up a discovery session, email, call, be glad to sit with you and go over your estate. And listen, there's not going to be a fee for that session if you choose to go forward and work with me. Of course, I'll include the fee in the ultimate set fee of the package of documents we choose to prepare for you. Listen, there are an awful lot of people that can whip out documents. It's not about the documents. It's about understanding who you are, what your values are, and where you want what you've accumulated to go after you're through with it. So I teach probate mostly as a cautionary tale, as a place you don't want your family to have to go. It is a fine system for people who have small amounts of assets. I would say under 70,000. If you have, say, a homestead and you've accumulated less than $70,000 in your lifetime, you probably don't need a trust, right? Taking it through probate is the quick and easy way to pass on to your heirs. Candidly, it's going to cost almost as much as a trust would have, but there's really not enough there to want to set up the trust and go through the formalities of keeping the trust active. For most people who have hundreds of thousands in accumulated assets, a home, maybe some other real property, probate is where your estate goes to diminish in value before your family can spend it. So I am at the end of my notes, and everybody stayed on for the whole session, so I must not have gone on too long. I haven't had any questions come up. Does anybody have a question that they would like to ask? I'll hang on just a couple of minutes. Well, I appreciate your attention this morning. I am looking around to see what we're teaching next week because I don't remember. I hope that you're staying sane during the pandemic. By the way, jokingly, he said, one pandemic and a lot of people have decided that it's time to plan their estate. Don't let it slip by. Folks put it off all the time. So next week, we are going to teach portability. Portability is the idea of taking the tax advantage of your homestead from one home in Florida to the next. And we are going to teach that live at the Casa Marina. There is, if you're not doing live events yet, there is already on our website at the webinars page a portability session that you can learn a lot for. I will say we have put a portability calculator now on our website. It's pretty cool, so that you can help your clients calculate their portability. So, hi. Oh, I do have a couple questions coming in. So that'll be next week live. If you're interested in attending that, get in touch with my team. So, supervised or unsupervised probate? Well, depends. Great question. Depends. You may want to hire somebody. Excuse me one moment. To watch over the probate of your assets. Many times we will probate or intentionally leave a small amount of assets out of a trust program so that it can be probated to get rid of unwanted creditors, if any, say from the last illness. I would say supervised or unsupervised. The answer is dependent on who you're appointing as your personal representative, whether you want to expend the funds to have someone supervise, and who you appointed, what faith and confidence you have in them to carry out the job without supervision, right? If it's somebody you want to be supervised, then I would certainly recommend that. Personal decision. Sorry, I can't do much better than that, but I know we'll get to discuss that offline as well. I have another question. As a real estate agent, what should we ask for to know the home is clear from probate and we can list it on the MLS? Fantastic. An order granting homestead. An order granting homestead status. And absolutely, to you, Rebecca, or anybody else that's a realtor on the call, if you've got some documentation and you're really not sure what it is because it's legalese, absolutely ask me. Send it over, and I'll be glad to give you an opinion on whether you're good to go. Typically, these days, we're going to want participation of all the heirs to give marketable title. So if we're moving forward in a probate scenario, let us know so we can make sure that everybody's on board and we don't have a hiccup at the closing table. Anybody else have a question? Those are both great questions. Thank you so much. We're coming in right at 30 minutes, which is what I'm told by the people that watch these is about the right amount of time. I will cue Lionel Richie and the Commodores with the Zoom song again. And I'll hang out for a minute in case anybody has a last-minute question they want to ask. Conclusion. Probate is a good process for people who don't have a lot of assets. Probate is a good process for a final determination of creditors who have a claim against the estate of a deceased person. Otherwise, probate is an onerous and expensive process that I encourage the majority of families that we represent to avoid. Thanks, everybody, for tuning in. Oh, good morning, Millie. Thank you. You have a great day, too. I hope this was informative, and we'll do portability next week. You are so welcome. Great question. Can an estate be probated without an attorney? It would depend on the state law. There is a process called an administration without, the word is not probate that goes there, an administration without something that is for teeny tiny estates that the clerk of court can help you through. I've actually spoken to the lawyer who works for the judges, the probate judges. They prefer that attorneys keep out of that process. So we really don't have much to do with those estates which, a non-lawyer citizen can handle for themselves and their family. Only the littlest ones. The probate rules are strict, intense, complicated, tricky. So even a summary, any estate that has over $1,500, $2,000 is going to need to hire an attorney to get it through probate. Good question. Rita, you're welcome. Thanks for being here. Well, okay, it seems like everybody's had their questions. I enjoyed being with you. I am John Miller, founding attorney at Rock Solid Law, and we'll look forward to seeing you again.